Welcome back to the deep dive. Today we are stepping right into the middle of a global race. But for once, we aren't just talking about who has the fastest chip or the smartest chatbot.
No, we're talking about the parallel race.
Right.
The one to figure out how on earth to control this technology.
It really is a fascinating moment, isn't it? You have this explosive tech, and then governments everywhere just scrambling to put guardrails on it.
And what we're finding in the research is that they aren't all building the same kind of guardrails. Not at all.
It feels like a diverging path. I was reading through the stack of reports we got from CISOmarketplace.com and compliancehub.wiki for this, and it just struck me, depending on where you live, the rules of the game are becoming completely different.
It's not a unified standard. It's a patchwork.
That's the perfect word for it, a patchwork.
Right.
And our mission today is to really tear that patchwork apart and look at the massive legal frameworks emerging in 5 key jurisdictions.
Right. We're talking the EU, the US, Canada, the UK, and Singapore.
And we're going to try to move past the boring compliance jargon. It's not about listing statutes. It's about understanding the philosophies driving them. Is it better to have a strict rule book or a more flexible playbook?
That is the central tension here. Hard law versus soft law. On one side, you have places that believe you need to write the laws in stone right now to prevent disaster.
And on the other?
On the other, you have nations saying, look, if we write the laws in stone today, they'll be obsolete by next Tuesday. The tech just moves too fast.
It's a massive amount of material to get through. Honestly, looking at these sources, it makes your head spin a bit. But we have to wade through it because the Wild West days of AI are effectively over.
They are. So where do we start?
Let's start with the heavyweight champion of hard law, the European Union.
The EU is absolutely the fortress here. They aren't asking nicely, they are legislating. And the core of their strategy is the EU AI Act.
And to really get it, you have to look at how they structure it, right? It's not just a blanket AI is scary law. It's more nuanced.
Exactly. They use this risk pyramid model.
The risk pyramid, right?
Think of it like a building code. You know, the city inspector doesn't really care what color you paint your living room. That's low risk. But if you're building a 50-story skyscraper,
a high-risk system,
then the foundation inspections are absolutely mandatory. They're basically saying innovation is fine, but stability is non-negotiable.
So let's climb this pyramid. At the very top, you have prohibited practices.
These are the things the EU just says are too dangerous to exist. Straight up bans.
Like what specifically?
We're talking about things like social scoring systems. You know, a government rating your trustworthiness based on your behavior. That is completely out. Also, real-time remote biometric identification in public spaces by law enforcement.
Wait, so strictly no facial recognition by police. What if there's a terrorist attack or a missing child? Surely there's some kind of loophole.
You'd think so. And there are exceptions, but they are incredibly narrow. The police essentially need to get a judicial warrant to turn those cameras on. It's not a just-in-case tool anymore.
It's a break glass in case of emergency tool.
Precisely.
Okay, so that's the top, the banned stuff. Then you step down a level to high-risk systems. This feels like where most of the corporate headaches are going to be.
This is the real meat of the regulation. It covers AI used in critical infrastructure employment decisions, like an AI scanning resumes or credit scoring.
So these aren't banned, but the rules are intense.
They are. You have to prove safety, you have to prove the quality of your training data, you have to prove human oversight, all before you can even launch.
And if you don't, this is where the research just made my eyes pop, the fines are astronomical.
They are massive. The EU knows the only way to get the attention of Silicon Valley boardrooms is through the wallet. If you violate the ban on prohibited practices, you're looking at fines up to 7% of your global annual turnover.
7% of global turnover. If you're a company like Google or Microsoft, we're talking billions of dollars.
Billions. Or 35 million euros, whichever is higher. Even for general violations, it's up to 3%. And get this, just supplying incorrect information to the authorities can cost you 1.5%.
That is a serious set of teeth. It reminds me of GDPR, but on steroids.
It's the GDPR playbook all over again. Remember how every website on Earth suddenly had those annoying cookie banners?
Oh, yeah.
That was Europe forcing the world to change. They're trying to do the exact same thing with AI. It's what people call the Brussels effect. Set a standard so high that global companies just comply everywhere because it's easier than making a separate product just for Europe.
There was one specific thing in the EU sources that stood out to me, and it feels like a direct response to the whole ChatGPT explosion, the rules for general purpose AI.
Yes, the GPII rules. That was a late addition, driven by that boom in generative AI.
Yeah.
The EU is mandating transparency. Providers of these big models have to publish detailed summaries of the content they use for training.
Which is a huge deal for copyright holders, right? If I'm an author, I can finally see if my book was fed into the machine.
It's a game changer for them.
But let's pivot. That's the hard law approach. Strict, binding, very expensive if you mess up. But what if you think those high walls just suffocate innovation?
Then you go the opposite direction. You prioritize speed and flexibility. And that takes us to the soft law strategists.
So we're talking about the UK, Singapore, and the US.
Exactly. Their philosophy is fundamentally different. They're worried that strict rules will kill the golden goose.
Let's start with Singapore. I love this example. A tiny nation, smaller than New York City, but they're ranked third in the global AI index, punching way above their weight.
Singapore is the agile innovator. They've explicitly decided not to have a specific AI law or a dedicated AI agency, at least not for now. They're using voluntary frameworks instead.
Like that thing called AI Verify. It sounds like a software tool.
It is,
Wow.
essentially. It's a testing framework that lets companies voluntarily check their AI against safety principles. It's not a cop telling you what to do. It's a tool helping you prove you're doing it right.
They also launched a generative AI evaluation sandbox. Now, sandbox is a term we hear all the time in tech. What does that actually look like for a business?
Think of it like a driving school. You're allowed to drive the car, maybe even make a few mistakes because the regulator is sitting right next to you with a second brake pedal. You don't get a ticket immediately, you get a lesson.
That sounds a lot more inviting than a 7% fine. Okay, so Singapore is the agile experimenter. What about the UK?
The UK has taken a sectoral approach. They decided against a big new blanket regulation. Their argument is, why create a giant AI regulator when we already have experts in banking, in healthcare, in human rights?
So the existing regulators just add AI to their plate. If you use AI in banking, the Financial Conduct Authority deals with it. Makes sense, but I have to play devil's advocate here.
Go for it.
Does a banking regulator actually know how a neural network works?
That is the big gamble. Can these legacy regulators get up to speed fast enough? The UK is betting they can, but they're also trying to lead on safety research to back them up.
Right, the Bletchley Declaration.
But a nice nod to history, Bletchley Park. The UK hosted a major summit there, got 28 countries, including the US and China, to sign on to cooperate against catastrophic AI risks. They also set up their own AI Safety Institute.
So the UK is basically keep calm and use existing laws, but also keep an eye on the apocalypse. Okay, now we have to talk about the United States, the home of the tech giants.
The U.S. is in a really unique spot. It's number one in investment and innovation, but its regulatory framework is fragmented. There's no single federal law like the EU AI Act.
It seems like they're ruling by memo.
In a way, yeah. Governance is largely driven by executive orders, like the big one, EO 14110. But a lot of the heavy lifting is done by the NIST AI Risk Management Framework.
And NIST is the National Institute of Standards and Technology, but that framework is voluntary, isn't it? If I'm a tech CEO, I don't have to follow it.
Technically, no. It's not binding law. The U.S. is relying very heavily on industry self-regulation, getting Amazon, Google, Meta to all voluntarily commit to safety rules.
It feels like the classic U.S. approach. Innovation first, regulation later, patch the holes as they appear.
It is. But there's a risk. While the U.S. builds sandboxes, the EU is building a fortress. And if you're a global company, navigating that map is a nightmare.
Which is why resources like compliancehub.wiki are so valuable right now. You just can't guess at this stuff. But speaking of the map, let's go north. Canada seems to be trying to carve out its own lane.
Canada's really interesting. They're charting a middle path. They have Bills C-27. And what's unique is that they've packaged their AI law ADA together with major privacy reforms.
Why bundle them? Why not just have a standalone AI law?
Because they see data as the key link. Think of it like this. Data is the ingredients, AI is the meal. You can't have a safe meal if the ingredients are spoiled. So Canada says you have to regulate data privacy and AI used together.
That actually makes a lot of sense. So is it hard law or soft law?
It's definitely leaning toward hard law. Like the EU, they're moving toward binding legislation for what they call high-impact systems.
High impact. Is that the same as the EU's high risk?
Similar concept. Systems used in employment, justice, healthcare. But here's where it gets really serious. Canada is proposing criminal provisions.
Criminal. As in, go to jail.
Potentially.
Hmm.
The proposal includes penalties for reckless or malicious uses of AI that cause serious harm. That's a step beyond just financial fines. They're putting personal liability on the table.
That changes the calculus for a CEO, doesn't it? It's one thing to pay a fine, it's another to risk a criminal record.
Exactly. But unlike the EU, Canada doesn't currently ban specific AI uses outright.
Hmm.
They're focused on risk management. They won't say no social scoring, but they will say if you do it and it hurts someone, you are in very big trouble.
So they're keeping the door open for innovation, but holding a very big stick. Speaking of big sticks and liability, that brings us to a huge battleground, intellectual property.
This is the real friction point, the messy world of copyright, because most countries haven't passed specific AI copyright laws yet. The courts are deciding the rules.
It's litigation as regulation.
Precisely. And we're watching this car crash in slow motion between AI companies that need data and the artists and publishers who own that data.
Hmm.
Look at the US. You have New York Times, the OpenAI.
Right. The Times is basically saying, you scraped millions of our articles to train your chatbot, and now it directly competes with us.
And OpenAI is arguing fair use. They say it's transformative, like a student reading a book to learn. The outcome of that case could change the entire business model of generative AI.
And it's not just in the US. In the UK, you have Getty Images Vstability AI.
Same idea, different medium. Getty says their images were scraped to train an image generator. If the courts rule that this kind of scraping is copyright infringement, these AI companies might have to pay billions in retroactive licensing fees.
And while the US and UK fight it out in court, the EU just legislates it.
Right. They just say, you must provide a summary of your training data. It gives rights holders the information they need to even know if they should sue.
So what did Canada do?
Canada took a separate track. They deliberately kept copyright out of their AI Act. They know it's too complex, so they're handling it through a completely separate consultation on Copyright Act itself.
Okay, so we have the EU Fortress, the US Singapore Sandbox, and the Canadian Middle Path. It feels completely fragmented. Is there anywhere they actually agree?
Surprisingly, yes. There's a lot of convergence, actually. Despite the different legal tools, they're all circling around the same core principles.
Okay, what are the shared pillars?
First, everyone is using a risk-based framework. No one is trying to regulate all AI. They're all focused on high-risk or high-impact systems.
So my Spotify algorithm is safe.
For now. Second, we see the rise of these state-backed safety institutes, like in the UK and the US. Governments realize they need their own technical experts to evaluate these models. They can't just trust the company's marketing brochure.
And the international cooperation seems to be real.
It is. The Bletchley Declaration was a big moment. And they're all collaborating on technical standards like ISO IEC 42001.
Okay, I have to stop you. ISO numbers usually make people's eyes glaze over. Why does this one matter?
It sounds boring, but standards are how the world actually runs. Think of it as the ISO 9001 for AI. It's a certification badge. Even if a government doesn't force you to be safe, your customers might. Companies will start saying, I won't buy your AI unless you have that ISO stamp.
So it creates a market-driven safety standard. It's like buying organic food. The law doesn't force you to, but the label drives behavior.
Exactly. And the final point of agreement is crucial. Existing law applies.
The idea that AI isn't in a lawless zone.
Right. Discrimination is still illegal. Consumer protection laws still apply. If an AI discriminates against you based on your race, that is already against the law. You don't need a new AI Act to prosecute that.
Murder is still murder, even if a robot does it.
Exactly. The new laws are just about closing the gaps that are unique to the technology.
So bringing this all home, what does this mean for you, the listener? We started by saying the Wild West is ending.
It definitely is. Whether it's through the heavy fines of the EU or high-stakes lawsuits in the US, accountability is becoming the global standard. If you build or buy AI, you can't just ask, can we build it anymore?
You have to ask, how do we govern it?
You do. And this brings us back to that Brussels effect. The provocative thought I want to leave everyone with is this. The EU has the strictest rules and one of the biggest markets. Will global companies just default to EU standards everywhere to be safe?
It's the path of least resistance, right? Why build two versions of the same software?
It is. But what if they don't? What if the US and UK stick to their soft law approach and encourage more aggressive innovation? We might see a truly fragmented internet.
A world where your AI assistant in New York can do things that your AI assistant in Paris simply refuses to do.
A balkanized AI world. It's a very real possibility. Where you are standing on the globe could determine your digital reality.
Well, on that note, Something to chew on while you check your local compliance laws. I want to thank you for guiding us through this maze today. And for anyone needing to navigate that maze professionally, definitely take a look at the data on CISOmarketplace.com and compliancehub.wiki. They were instrumental for us.
My pleasure. It's a complex landscape, but an important one to understand.
And thank you for listening. We'll see you on the next deep dive.